Welcome back. You're watching the Urban Debate. And as you know, yesterday, the committee of 3 judges handed a clean chit to the Chief Justice of India over allegations that were made at him by one of his former staffers. Today, as you will see visuals on your screen, protests took place across the country. In Delhi, outside the Supreme Court, several women's rights activists protested. They were then taken into custody by the police, who detained them at the police station for several hours. This was followed by a protest in Bangalore and then by a letter signed by 350 women's rights activists. They demand that the Select Committee's report be made public. They demand that the Vishaka guidelines be followed, as they allege the guidelines were not followed in this particular case, and the principles of natural justice weren't followed either. To begin with, we want to understand if the protesters are in the right and if their questions should be answered. On the show with me, Prashant Bhushan, Senior Advocate with the Supreme Court. Mr. Bhushan, good evening and thank you for joining us. I appreciate your time. I'm sure you've seen the letter that was written by the activists and, of course, the placards that they were holding up this evening. If we were to break up their demands, first of all, the allegation that Vishaka guidelines or due course was not followed in this case, do you believe that that allegation has any substance to it? Was due process followed in this case?
Well, you see, due process would firstly require that the Chief Justice not be judged by colleagues who are sitting with him day in and day out, whether in court or out of court. Due process and natural justice requires a committee of people who are not such close friends or such close colleagues of the Chief Justice. And that is why in her first letter to all the judges, she had asked for a committee of retired judges or any other persons who would not be so close to the Chief Justice. Second principle of natural justice, at least in this case, would be that she should be required the assistance or the help of a lawyer or a support person, which is what the Vishaka guidelines also require, that at least a support person should be allowed. And it also required for the committee to lay down some procedures so that she would know that what are her rights, whether she would be entitled to cross-examine witnesses, whether she can ask for other evidence, etc. For example, she had asked for the phone call records of the Chief Justice and the Secretary General, etc. to be examined. We don't know what happened because eventually she was forced to walk out when these demands for having a lawyer or a support person, for recording the proceedings of the committee, for informing her about the procedure, none of these were met, and therefore she was forced to walk out. And thereafter we just learned from the newspapers that the committee called the Chief Justice. We don't know whether they called anybody else or not. And then suddenly we find that the committee has given a clean chit to the Chief Justice, but they will not make the report public. I mean, it's rather unfortunate, and it has shown the Supreme Court in a rather poor light, and that is why it is facing so much criticism, not just from women's groups, but also from so many very respected jurists, lawyers, etc., who have been now writing and speaking about this.
Mr. Bhushan, you did say, of course, that the first point would be that the Chief Justice not be judged by colleagues and friends. But there's an argument here from other jurists who say that 3 Supreme Court lawyers would be the highest bench in the country. And to actually say that they should not be in judgment of a fellow judge or a friend would be bringing their independence or bringing their credibility into question, which shouldn't be done. What's your response to that?
It's not a question of bringing, you see, their credibility into question. It's a basic principle of natural justice and justice being seen to be done, that the judge should not be one about whom the litigant can have a reasonable apprehension of bias. Now put yourself in the situation of the complainant. Would she not have a reasonable apprehension of bias about people who are such close colleagues and friends of the Chief Justice, who are sitting with him whether in court or outside court almost on a daily basis? And when there is, last time when a complaint was sent to for an in-house inquiry against the previous Chief Justice, the judges felt that there was no procedure laid down and there was no scope for an in-house inquiry against the Chief Justice under the in-house procedure. So clearly the full court decided to lay down something extraordinary to have this in-house inquiry even for the Chief Justice. Why couldn't they have an inquiry of 3 retired judges, out of which 2 could have been women, 1 or 2 could have been women, headed by a woman? I mean, that would have certainly people who are not known to be close friends to the Chief Justice or close colleagues of the Chief Justice, that kind of committee, inquiry committee, would have carried some credibility. Unfortunately, this, and especially with the lack of any procedure, not allowing her even to have a support person or a lawyer, not recording the proceedings, clearly the proceedings of the committee lacked any credibility.
Mr. Bhushan, you did say, of course, that the complainant was forced to walk out of this investigation or this committee inquiry. The other point of view is that the complainant walked out of an inquiry that was brought in, to look into her case because she knew that she didn't have the evidence to, for her case to actually hold up. And the fact that she walked out is the main reason for the clean chit. Because if she knew she had a case, she should have seen it through. What's your response to that argument?
You see, she had submitted the complaint with a great deal of documentary evidence. And the documentary evidence was in the form of photographs, videos, other documents showing that she had indeed fainted on the day when the domestic inquiry was held, and despite the fact that she was in the hospital, the inquiry was declared ex parte and she was held guilty on the same day on 2 very, very frivolous charges of taking half days leave as well as complaining about the frequent change of her seating, etc. Similarly, she had submitted documentary evidence of her being shackled, handcuffed, foot cuffed in the police station, her husband being handcuffed. She had submitted video evidence of the SHO who was admitting that he had taken her to the residence of the Chief Justice, where she was made to apologize to the wife of the Chief Justice in a very humiliating way. Now, how did the committee deal with all this? Why is the report not being given to her? After all, is she not entitled, even under principles of natural justice, to have a copy of the report and the reasons as to why her allegations, which were documented with so much evidence, have not been accepted? Ex parte doesn't mean that you disregard the evidence that she has submitted.
Absolutely. Mr. Bhushan, in your opinion, do you believe that this, in the minds of citizens across the country, specifically women who perhaps are looking for justice in similar cases of workplace harassment, does this draw into question the independence or the commitment towards women's rights in this country?
Yes, that, but more importantly, it shows that we do not have any proper system of inquiring into allegations made against judges. We just don't have any proper system of that. Even if you were to file an FIR of sexual harassment under the normal criminal law, you would require permission of the Chief Justice, or
Yes.
against the Chief Justice, you need permission of the President. Therefore, we need some law and some system by which allegations, whether of criminal misconduct or any other misconduct against judges, can be inquired into by an independent, credible body. Unfortunately, we don't have any such system today in this country.
Yes, Mr. Bhushan, many thanks for joining us here on Mirror Now. During the urban debate, we appreciate your time. Prashant Bhushan, with his views on the protests currently and the clean chit handed to the Chief Justice of India on the matter of harassment, or the allegations that he was facing in the matter of harassment. Joining me on the show right now to take the conversation further, Karuna Nandi is a lawyer with the Supreme Court, Anjali Bharadwaj, a social activist among those who protested today, Kailash Vasudev, senior advocate with the Supreme Court, Aishwarya Bhati, also senior advocate with the Supreme Court. I welcome all of you to this conversation. Thank you for joining us. Mr. Kailash Vasudev, good evening, and thank you for giving us your time. You heard the arguments just made by Prashant Bhushan. And I'm sure you'll have rebuttals to each of them, but I would like to break them down into pieces so it makes it easier for our audience to understand. One of the first points that has been raised, both by the activists and Mr. Bhushan, is about creating a panel or a committee of perhaps retired judges or people who were outside of the Supreme Court. Serving judges of the Supreme Court effectively are associated very closely with the Chief Justice of India, and hence might not be able to or go against the principles of natural justice because they continue to work with him and they're friends with him. Your response or your rebuttal to that, Mr. Vasudev?
Good evening. First things first. The committee constituted by the Chief Justice consisted of Justice Bobde, Justice Ramana, and Justice Banerjee in the first instance. An objection was raised to the presence of Mr. Justice Ramana. He demitted, or he declined to continue, and therefore Justice Indu Malhotra was brought in. So you have 3 judges of the Supreme Court, 2 ladies, and a gentleman who's supposed to be the next Chief Justice of India, to head a committee to inquire into charges against the Chief Justice. You have a committee which is called the Gender Sensitization Committee of the Supreme Court, which is a very wide-based committee, which looks into, or which is supposed to look into, allegations or charges of this kind. In this case, that committee was deliberately given up to appoint 3 judges of the Supreme Court to inquire into a matter. I must say that at points of time when an inquiry is to be made into a serious matter, only 1 judge of the Supreme Court is appointed by government to look into those charges. Here you have 3 judges, 2 ladies, and a prospective Chief Justice to look into this. Are we trying to say today that because they've given a report closing the matter, you're going to challenge their integrity? Are you going to turn around and say that they were wrong? Because nobody knows what happened in the proceedings. We are proceeding on the basis of surmises and conjectures that this happened to the lady, she was not given an opportunity and the like. On the other side, the second statement made by Mr. Bhushan just now was that possibly the material placed on record was not looked into by the committee before coming to their finding. The simple question here, the report of the committee is not public. We are drawing surmises, conjectures, and assuming that the judges supported the Chief Justice because he's a member of the bench. Is that not a bit strange? That you are casting aspersions on 3 judges of the Supreme Court, whose judgments you follow every day without casting an aspersions on the correctness of their decisions. You accept their integrity in judgments, and you decline to accept their integrity in such matters of great national importance.
Yes.
As we read from the press, I'll take 2 minutes of your time.
Yes.
As we read from the press, the lady declined to continue with the inquiry further. We can draw surmises, we can draw conjectures, but I'm reasonably sure that no Supreme Court judge would not have called the lady again to make a statement. What stopped her? What was the reason? When the Chief Justice himself appeared as a witness for himself, he must have been cross-examined. His statements have been recorded. Do you realize what we have done? We are now casting aspersions in the interests, or rather against the interests, of an institution which has been held to be in great respect by our people. We are now allowing all sorts of allegations to be flung around the place for the purposes of denigrating an institution which seeks to keep itself clean. It is a clear case of judge bashing. When you have judge bashing, the judges don't have a chance to stand up and come to the press and say, look, I didn't do this. It is not the convention. The convention is to accept the situations, let them low, let them lie, let them go away. Because the judge can't turn around and make a public statement in any press channel or otherwise, or write a letter to the press saying that, look, this is all nonsense. He will not do it. That is not the convention. His convention is to function in the correctness of office. This is what the three judges have done. If today you are going to turn around, challenge every decision of the court, cast an aspersion, it's normal today. You lose a case and you say the judge is corrupt. Is it fair? How are you going to run the justice system? These gentlemen work 20 hours a day for the purposes of reading hundreds of paper books to deliver the judgments. None of us can turn around and say in the court that they have been unfair or not given you a hearing. They have exercised their discretion. Here, they've exercised their decision after possibly looking at the records. No one knows what happened.
Yes.
On surmises, conjectures, you are damning the institution. Is it fair?
Yes.
I don't think it is. Let them, they have taken a decision. If any further steps are to be taken by this lady, it is open.
Yes.
No one has stopped her. She hasn't come forward. This is where the questions arise. On the other side of the argument, why was this case started? What was the reason behind? And why didn't it continue with the same force and power with which it was instituted? When a petition or a complaint was drafted and settled by 4 or 5 advocates of great eminence.
Yes.
What happened to them in the committee? Why didn't they come forward and volunteer?
Yes.
What stopped them?
Well, let me open this up to rebuttals.
You should have come forward and said, look, we'll appear for the lady.
Let me open this up for rebuttals. Karuna Nandi is with us. She's a lawyer with the Supreme Court.
You should have come forward.
Yes, she's also been fairly vocal on the matter. Ms. Nandi, you've heard again Mr. Vasudev's arguments. Why challenge the integrity of judges of the Supreme Court whose discretion on judgments we accept without question on a daily basis? This is the highest house of justice in the country. And when the complainant herself declined to continue, is that not evidence enough to suggest that she didn't have a case? Ms. Nandi.
While Mr. Vasudev's sympathy with the judiciary is not misplaced, because what he's saying is that they can't speak, outside of the confines of the bench, that they work very hard, etc. All that is well taken. But sir, it cannot blind you and it cannot blind the court, it cannot blind any of us to the various violations of law that bind the rest of us. You see, what are these violations? The Prevention of Sexual Harassment Act does not explicitly actually exempt the judiciary. What it says is that there will be a committee of 3 with a majority of women, presiding female judge with an external member. This did not take place. You say, sir, that judges are constrained from speaking in their own defense. Now, I actually strongly have sympathy on that count. However, in this case, the Chief Justice, on a Saturday, the morning after these allegations came out, constituted his own bench. So I don't think that in this case is a particularly good place to raise this. Also, according to me, the Mirajkar judgment, by which it has been said that the judiciary cannot of itself, that the court cannot in and of itself issue a gag order. According to me, there has been an implicit chilling effect, or perhaps an implicit chilling effect was intended in the order issued based on that hearing on Saturday, which actually the Chief Justice did not sign, 2 other judges signed, and asking the press to take down the allegations. Now, you say that nobody came forward to represent this woman, the complainant. The complainant asked for representation, sir. There you are in factual error. The complainant asked for representation, and she asked for the kind of representation that is allowed in the context of the Prevention of Sexual Harassment Act. We are told that she asked either for assistance with another employee of the Supreme Court, but in this case, of course, she should have been given either a lawyer or an amicus curiae, given the fact that the huge, massive imbalance of power. I would also like to say that I don't think that Mr. Bhushan is entirely incorrect either when he is saying that the committee should have been over and above and beyond the requirements of the Prevention of Sexual Harassment Act, which is that it should have been an external committee altogether. And the reason is this, and there is a legal reason for it, is that there is no judicial review maintainable against this order of the internal committee. If there is something wrong with this committee, where does she go? Can she go to a high court? Can she go in a writ, which is where she would go if it was any other committee in any other workplace across the country? She cannot go in a writ because a high court judge would not have the courage, would find it extremely difficult, although maybe she should try, who knows. So the point is that here we have a situation where various laws, judgments regarding the hearing of such a case, regarding due process in such a case, where have not been complied with at all. And in lurching from one mistake to another, in the end, this order should not have been passed.
All right, I want to give Mr. Vasudev
participating. What are the odds that there would be an order that would be, fair? Right?
I want to give Mr. Vasudev an opportunity to rebut, and also Mr. Vasudev, Mr. Prashant Bhushan ended his comment by saying we don't have a system in place. I believe that's what Ms. Nandi is also talking about. When the person in question or when the allegation is against a sitting judge of the Supreme Court or a Chief Justice, we don't have a system in place right now that actually works. So do you want to rebut what Ms. Nandi has said and comment on also Mr. Bhushan's comment on the lack of a system?
Yes, I will.
Yes,
I will.
Please. Go ahead.
Let me give you a very recent incident which took place when Chief Justice Kehar was in holding office. Allegations were made against a sitting judge of the Madhya Pradesh High Court by a subordinate judge making allegations of sexual harassment at the workplace against him. The matter was inquired into, and it was inquired into by sitting Chief Justice of another High Court. He looked into the matter, made a detailed report after the Supreme Court's prima facie order on this matter. That report was inquired into. The sitting Chief Justice of the Madhya Pradesh High Court abstained from participating in the proceedings. He said, look, eventually I got to sign the orders. The orders, the decision of the Chief Justice and his committee came absolving the judge of his allegations. Now on the second thing, so there have been inquiries which have been conducted in similar circumstances earlier that are part of the judicial record. Number two, the fear that the High Court would not be able to set aside a judgment of the Supreme Court, or rather an administrative order of the Supreme Court, is again wrong. There have been cases in service matters. There have been cases under the Right to Information Act where the High Courts have told the Supreme Court, you will disclose all the information under the RTI Act. That appeal is now pending in the Supreme Court. It is coming up before a bench. So the High Courts have the extraordinary power under the writ jurisdiction to decide any matter, administrative or otherwise, even of the Supreme Court, which they have done. To say that the High Courts don't do it, it would be saying that the High Courts are shying away from their duties, which again is incorrect. We come to the third aspect of it, of Mr. Prashant Bhushan's caution, that you should have a committee which should be fair and independent. Well, we have a committee. We have a gender sensitization committee of the Supreme Court, framed by regulations under Article 141 and 142. That committee was not constituted this time, but two lady judges of the Supreme Court were brought into the committee. So the concept of gender sensitization by a larger bench, larger representation of lady judges was followed. All these aspersions, all these views, this has happened, that happened, this didn't happen.
But then, Mr. Vasudev, do you believe that a writ should be filed to review
the lady
this
has not
order?
made a statement.
So if I may just ask one question.
Yes, if you want to, please go ahead. You have the power. Yes.
Do you believe that a writ should be filed to review this order?
I have an answer. You go and file a writ petition.
She's not my client. Okay, so you do feel a review should be filed.
Right, go ahead.
So you do feel a review should be filed.
If you feel it should be done,
a writ should be filed against this order.
I feel that if you want to take recourse to legal, the court doesn't stop you from taking legal recourse. Let the lady take legal recourse to wherever she wants. There's no stoppage. The court hasn't put a bar on it. And the order of Saturday, which was passed by Justice Mishra and Justice Khanna, was, I leave it open to the press to decide what is to be done. There was no gag order. The Chief Justice recused himself. He made a mistake maybe of sitting on the bench, but he did not participate in the proceedings. You have cast aspersions on a man. Today he has been, should I say, discharged of those allegations. Now you take recourse to whatever is available to you. Please don't carry the situation into a matter that you want to continue to malign the man.
Yes. Let me bring in my other two guests, please, if I may.
You're maligning the senior most law officer of this country who upholds the justice system.
Yes, let me bring in the other two guests as well. Aishwarya Bhati is a senior
I think
advocate.
it's very, Faye, if I may just come in here, I think it's very important to come in here. I think it's very important to come in here. Just very briefly. Mr. Vasudev, I think it's very important to say here that from Justice A.P. Shah to a large number of senior counsel who have spoken up on this matter, to a large number of lawyers, nobody is seeking to malign the Chief Justice of India. This is spoken from a place of regard for the Constitution, for due process, and for the institution of the Supreme Court. I think it's extremely important to respect these views in this light and to not sort of cast oneself as the savior of the court where there is a situation that is going to the root of Article 14. So, while we may have a disagreement on the substance, let us not malign each other in this regard. Now, over to the other panelists.
No, I'm not maligning anybody, ma'am. Please.
Yes.
I have no intention of maligning anyone. You have a point of view, I have a point of view. You have a perspective, I have a perspective. I'm raising my perspective.
Nobody is maligning the Chief Justice.
I'm not trying to
that the way that the process that was undertaken was incorrect.
Fair enough. I just want to hand the floor to Aishwarya Bhati. She's a senior advocate with the Supreme Court. Ms. Bhati, also as a woman citizen of this country, as a member of the legal community, where do you stand on this matter? Do you believe that the questions that are being raised in the process are valid?
Well, Faye, today I'm a little surprised that eminent lawyers who have nuanced understanding of the Constitution are raising very interesting points which are frankly beyond my comprehension, because what is being done, in my opinion, is it's following the due process to the T. It is following the constitutional norms to the manner in which it has to be. Constitution provides immunity. And it provides an immunity to whom? To President, to Governor, to judges of the Supreme Court of India, judges of the High Court of India. That is prescribed in the Constitution itself. Somebody was mentioning that, the Sexual Harassment Act does not exclude the judiciary. No act excludes the judiciary. But the judiciary, High Court judges and Supreme Court judges have an immunity under the Constitution, and that immunity comes for the reason of the office that they hold. We have to understand and appreciate that that office exposes them to a lot of a lot of issues. In fact, I want to read out the last two sentences of the in-house the procedure that has been adopted by the full bench of the Supreme Court in 1999. This is a procedure that was formulated, a committee was set up, and the entire proceedings now have taken place in terms of that procedure that was set up in 1999. And the closing paragraph, of just the closing two lines of that in-house committee procedure is very interesting. It's almost like, it almost reflects on the situation that we have at hand today. So the first thing that the committee says is that this in-house procedure will allay the misgivings in certain quarters that members of higher judiciary are not accountable for their conduct. And secondly, at the same time, it will also serve as a safeguard for members of higher judiciary from being maligned or being subject to vilification by false and frivolous complaints. Of course, the committee does remark that we hope that such occasions seldom arise, but it will happen. And this is very, very telling. This is how the committee has laid down the procedure. The procedure is laid, you have to understand the constitutional immunity and then the procedure, so that there is no misgiving. At the same time, there is protection because of the office that they hold. Yes. And then an in-house procedure is absolutely, today we want to just paint the whole institution like that. We don't even realize what is at stake. This is the very same institution which has been a lighthouse to our democracy, which has been a savior to the citizens' rights and liberties. All of us go to Supreme Court of India, not as just lawyers. I mean, as citizens, we look up to the Supreme Court of India. Now, point is, now,
okay,
now
okay,
point
all right,
is
hang
there
on,
are,
hang
you
on,
know,
hang on. One second,
let me- allow me to
Ashwaraji, just,
complete.
I have
will
one
not
more, I have
interrupt.
one more
more
guest to
point
bring in,
make.
if I
You know,
may.
I have one more point to make.
Okay,
One
all right,
second.
all right, all right, fair
One
enough.
second,
Make
Faye,
it,
I
make
have
it.
one more point.
Okay.
Just 1 second, Faye. Just allow me to make one more point. You know, who's on the committee? Who was on the committee? Kailash sir has very clearly, highlighted that aspect. But I want to ask you a question today. It was fine when one of the lady judges, both the lady judges are very respected on the committee. So is the Justice Bobde, who will be the next Chief Justice. But it was fine when this lady judge, who is incidentally also the first woman lawyer to be designated senior by Supreme Court, the first lawyer to be elevated to the bench from the bar. It was fine. She had the courage it was fine. We were all lauding her courage when she wrote the minority judgment in the Sabrimala case. That time it was all fine. She had the courage to do that. She does not have the courage to dissent today. I mean, what are we talking about? Now we are completely up in arms against the institution. Let's stop it here and now.
All right. 1 second, 1 second. I also have Anjali Bharadwaj with me. She's
Nobody's
a social
impugning her
activist.
courage either, Aishwarya.
Right, Anjali Bharadwaj is here. She's a social activist. She's not a lawyer. She's among those who protested.
These are not things that are being said, you see.
Outside the Supreme Court. Anjali ji, your point of view and why you felt it was necessary to protest outside the Supreme Court.
Look, Faye, I've been listening to all the various panelists, and let me start by saying that I think as citizens, as women who are citizens of this country, we are extremely concerned about the credibility of this institution. So if Mr. Vasudev wants to say that we are tainting the institution, I completely disagree with him. We are extremely concerned. We feel that the process that has been followed, and nobody is casting any aspersions on any judges, so we don't want or we don't need anyone to hold a brief for any judge. But what we are saying is that the process from the word go has been arbitrary and it has been problematic. From the very beginning, the moment the Chief Justice set up a bench, the allegation came and he set up the bench, he presided over it, there was a problem. In that particular case, the woman, the complainant, was not even present. There were remarks made about her, about various things. There were very important things that were said which could have a very, very significant bearing on the eventual outcome. And she wasn't even present there, and the Chief Justice was there. And these are allegations against one of the most powerful people in the country. And we need to recognize that with great power comes great responsibility. So what we needed to see was for the court, for the Chief Justice to stand up to the occasion and to react in a manner that was befitting the institution and the chair that he occupies. I think the problem here has also been with the functioning of the committee. It has been in violation of the spirit of the Prevention of Sexual Harassment Act with the Vishakha guidelines. The complainant has not been allowed to have a lawyer. There's been no external member. And also look at this, the Chief Justice continues to be the administrative head, and she has named people in her complaint. There are witnesses, there are people who are working under the Chief Justice. Would it not have been correct? Because how can we expect these people to, without fear, actually depose and say what they have to say while the administrative head continues to be the Chief Justice? There are all manner of problems that have
Anjali ji,
come
allow
up
rebuttals.
which actually erode the credibility of the institution. And finally, let me also finish by saying that, look, the final nail in the coffin has been that the complainant has not even been given a copy of the report. Look, don't make it public, but at least if she needs to challenge it, go anywhere in writ or whatever else, should she not have a copy of the report? How can we expect anyone, any citizen, any woman today in our country to have faith? And we can keep saying that the institution is important. Of course we agree it's important, which is why we believe that it is worth fighting for the credibility and the proper functioning of the institution. Women are today looking and saying, if this is what is going to happen in the Supreme Court, what hope is there?
All right, I'll allow rebuttals, and here's the question of either A, making the report public, Or secondly, like Anjali ji pointed out, at least allowing the complainant to have a copy. Mr. Vasudev, if you have a response on that, do you believe that this should be allowed, that the complainant should have access to a copy of the report? Because like you said, if she wants to seek further, judicial recourse, she needs a copy of the entire report.
Remedies, yeah.
Yes.
You see, she is entitled to the copy of the report and I'm sure she'll get it.
Okay.
She's only got to ask for it. I don't think anybody, by the existing law systems as we stand in our country, starting from ECIL and all that, the complainant is entitled to the inquiry report. She will get it. I don't know, ma'am. I'm not a part of the committee, not a part of the Supreme Court. If you know about it, good for you. But you must then be able to say when she asked for it and how. And how do you know about it?
Anjali says she has asked for it.
No, she's asked for it, then it's for the
made
court
a
to decide to
request.
give it. I'm sure the
If
court will
she's
give
not
it
been
to her.
given it, you believe that
It's
she
only
should
day
be given
before
it.
yesterday the report came, they will give it to her. You see, but please understand, I am not here in a position to comment whether the court has, I mean, she's applied, not applied, I don't know the facts of the case. You asked a question, whether she's entitled to it. Yes, she's entitled to it. That's my say. She will get it, I'm sure. The Supreme Court is not going to hold back a report if it involves an individual. That's a settled law. Now, the second part of it, it was communicated that I'm holding a brief. I'm not holding a brief. If you are fighting for the institution, so am I. Your views are on the other side, mine are on the other side. Aishwarya Bhati has also very rightly said what the Committee of Sensitization has said in its last few lines, don't malign the judges. That is what I said. The report says so. I refer to an instance from Madhya Pradesh where this judge was eventually absolved of the charges, but it destroyed him. His integrity was questioned, his actions were questioned, and in the end of the day, his position in the judiciary was compromised. Making these kind of allegations, after having it been found to be false, and then carrying it forward by making this kind of allegation that the committee was biased, that the judges were together, that the committee was not a part of the system which is to be followed, I think is very wrong. You have judges of the Supreme Court. Please understand, a judge of the Supreme Court is a person with impeccable respect.
May I come in here?
You have two lady judges. Are you saying they didn't do the job? No, it's not a question if you're coming in, I'm asking you. There are three judges, two lady judges, one Supreme Court judge, all Supreme Court judges.
Well, just one second. I want to take this back to Karuna.
It is very difficult to accept all these kind of allegations.
This is a question both Aishwarya Bhati and Mr. Kailash Vasudev have brought before us, which is that if you are suggesting that there's a problem with the committee because they're friends or colleagues of the Chief Justice, are you in any way doubting their ability to separate themselves from that relationship or be able to make a judgment that is independent and unemotional? Or are we, like Mr. Vasudev said, casting aspersions? Or are you casting aspersions on their credibility?
I think it's very important to remember that I do not believe that it is because they are colleagues of the Chief Justice that this committee should not, should have been constituted somewhat differently. It is because they are, in an administrative manner, junior to the master of the roster. There is a degree of administrative control that the master of the roster has over his other colleagues. He is the first amongst equals. There is a judgment, there are various judgments concerning the principles of the Prevention of Sexual Harassment Act. Now, while it is true that there is a constitutional immunity that the judges have, that because of the constitutional position they occupy, because of that, the principles of due process and fairness and transparency that govern these institutions must be even higher. What one is saying is this, and that the judgments that look at the process in the Prevention of Sexual Harassment Act say very clearly that you cannot have your juniors making decisions for you, regarding you. And so therefore, this is why a special inquiry committee was sought, perhaps by the complainant, and I think that this was a good idea. However, I diverge from Mr. Bhushan, where I do not think that it is because they are friends or colleagues. It is because I think that they are under the administrative control of the master of the roster, that it could have been differently constituted.
Yes.
What one is saying also is, let me be very, very clear. I think it's very easy to, when one is appearing before judges, to argue sort of, I'm not saying that any of you do, but I think, to say it's a very difficult position in which many of us, and Justice A.P. Shah, whether it's Dushyant Dave, whether it's Rakesh Dwivedi, Dinesh Dwivedi, Meenakshi Arora, that's a very difficult position for us. Because we argue before
the same judges,
these judges all the time. What I am saying is that it is not impugning the individual integrity of any judge. Nobody is saying that the Chief Justice is guilty. Nobody is saying this. Nobody is maligning the Chief Justice at all. What one is saying is that when you are at a level of the Supreme Court, that due process
I have to unfortunately leave it there because we've run out of time. But we're going to, obviously for citizens in this country, the Supreme Court is, it holds the highest confidence. When all else fails, we look towards the court. So this is a case or a particular instance or a story that people across the country are watching very, very closely. I thank my panelists for giving us that time to help us understand it perhaps a little better as to what is really going on with this case. Thanks for watching.